minutes to start. So guys, we are here to talk about trademarks and everything about trademarks. And I want to tell you, I fell in love with trademarks because when I started working on the gaming side, I had to create a portfolio of 300 trademarks. And 300 trademarks was later. But when I started into the gaming industry, the first day I was dealing with the litigation on trademarks, which was around 35 crores. Yeah, it was a huge amount 6 years back, right? And that made me understand that, when it comes to digital, IPR is no less. IPR is equally to be protected. And I'm here only talking about trademarks. So what does trademark actually mean? We've heard so much trademark, copyrights, and all that which comes under IPR. But what does it mean? Let me break it. That's what I do for everybody I come across. See, the word trademark is made of two words, trade and mark, right? So what is trade? Trade is business. If you understand it in the most general term. And the second part of the word is mark. Mark means an indication, a symbol, a signature, whatever that gives a significance to that particular trade because of which it can be recognized is a trademark. So for today and forever, you guys make me proud when if somebody asks you what is a trademark, you explain them in a similar manner, okay? The business has a particular symbol to it, by which it gets its brand identity. If we speak it in more fancy words, the brand identity is the trademark. It's the mark of the trade. It's the brand of that trade. Trade can be anything. It can be of goods or services. There is nothing other in trade, right? The category that trademarks provides is also for goods and services. I'm going to speak about it. There are 45 such classes, but always remember it's either goods or services, and the symbol which denotes is the trademark. Is that clear? Now, first, even before we get into trademark, you guys need to know there are 5 major types of IPR. When I say IPR, it means intellectual property rights. Intellectual property rights means what? Again, I'll break it for you. Intellectual means here, something which is coming from the brain, something which is coming from the mind. And when you are the brainchild for it, when you are bringing it out, it's your property and you have a right over it. And that is what intellectual property right is. Here, everything, be it copyrights, be it trademark, be it trade secrets, be it geographical indications, or be it, all those other categories, everything is under IPR because it is starting from here, the brain, from your mind. You are the owner, and that is why you are the property owner of that. That is why it is under intellectual property rights. Do you get it now? Why IPR and then why these 5 categories? And under these categories, only those things are being captured, which is your brainchild, okay? And you are the owner. When I say the owner, there's very interesting discussion when you get to understand this from the copyright side, but we're not divulging into it at this moment. Into trademarks. So broken the word trademark for you. I've explained why does it come under IPR. Now, let me tell you, trademark has a lot of variation. You cannot say that only one thing is a trademark. From a symbol to a logo to a particular way of designing a name of a particular brand is also a trademark. So when you see Nike's logo, you just know that it's Nike, right? You don't have to go and read it on the shoe. You see that right wala, just do it wala mark, and you know it, right? Similarly, when we go for H&M and Zara, we see that the way shop is. We don't look at the, okay, am I entering into H&M? Am I entering into Zara? Just their feel, their outlook, their way of representation. From far, you know that the shop is right there. Why? It's a particular layout, it's a particular representation, and do you know all that is trademarked? Nobody can copy it, the way they present themselves. So that is also trademark. So trademark can begin from a word, it can begin from a logo. There's something called device in trademark when you fill the application form. Device means when you're filing for the word and the logo together, it becomes a device mark. So don't get confused. If your senior ever tells you that, hey, this is a device mark, know that you are speaking about word and logo together. You can separately file for word and logo, but when you file a device mark, it is far more powerful. Again, when I'm speaking about this, it is coming from a lot of case laws that I'm speaking of. It is not in the books. This is not theory. It is coming out of all the experiences that I've had. All right. Apart from this, there are many classes in trademarks. Why are these classes? Because there is an application form which you have to fill to get a trademark registered. Registry of trademark is not mandatory. Let me tell you. Why do you register? I will come to that after this. But first know that there are classes. How many classes? 45. Divided 1 to 35 is goods. 36 to 45 is services. Okay. And these classes makes it very easy that you understand that which category your product or service will be. Say, I'm coming from the gaming industry. I say, I need to trademark a particular logo of gaming company. But I'm speaking for a gaming company. So I will go through that list, which will speak about computer devices, which will speak about sports, which will speak about game. And wherever I best fit in, I will pick up that class and put in my application. The more exact, the better. So your trademark registry doesn't reject it for you. Are you getting this? Are you guys with me? Am I making sense? Yes, no, something on the chat. Yeah, 56 people. I can at least have 10 people responding to me. Thanks, Ishika. Okay, I see a lot of thumbs up, but I don't see the names. No. And you, Vedvati, thank you. Shresht, I am elaborating. You keep listening, you will understand. Or in the end, please feel free to ask your questions. Mehak, Kavya, Vanshita, Sahil, thank you. Thank you. So these classes are very important. How do you understand? How do you remember? Of course, when you file a lot of trademark applications, you start understanding that for this particular industry, these sections or these classes are always dominant. Like for me, in my gaming industry, I know these classes is which I will refer to. Yeah, but if I'm working for some other industry, I will know that there are particular classes that I will refer to. So if you look at the list, feel free. As a lawyer, it doesn't mean you have to have everything in your brain. It means you can look at the list, find the closest one. At times, if it is closest but not defining your product well, put in a word in that particular section which is defined and which gives clarity to your product. It will help you get over the rejections which you might face in the examination report. What is examination report? I'll come back to later, but understand this. I'm sorry, I'm with a bad cough. So that being said, classes are very important. You need to know about it. Goods and services, and then bifurcate it. Choose the closest. If needed, put in the right word which defines your product or services and put that class in filing of your trademark application. So after understanding these classes, if you want to understand the list of those classes, just go today on the IP website. Yeah, just Google IP website, official website for India. You will see they have that trademark goods and services list. Just download it and keep it for your reference, because every time you will be filing it, you will be referring it. Until and unless you are too sure, you worked in that industry for too long a time, then you become sure about it, but refer to it. Now, I want to give you a little bit of idea before moving further. Trademark, so that since you've understood that what is trademark, so everything is trademark around you. Yeah, my brand Laws with Rachna is a trademark. Legal Vidya is a trademark. Yeah, you do anything is a trademark. You know, Patanjali is a trademark. To a Dabur is a trademark. Everything around is a trademark. If there is any business running behind it and they have protected the brand, it is that they are protecting the mark of the trade, and that is a trademark. When registered, it gives you extra protection, but there is nothing which is mandatory as such. It is, but let me give you the actual possession. it's good to have your trademark registered, because then the first line of defense, the first line of evidence is always ready for you to fight it out in the courts. And the moment there is an infringement, and if you have your certificate in hand, you are far stronger than just trying to prove your claim and ownership of it. When you have the certificate in your hand, you are legitimately out there saying that, hey, I am the owner. And this has worked a lot in our favors. That also helps you in getting down an injunction order in your favor, which is Dilshad, now can you hear me? Is that fine? So you need to register even while you start working as lawyers very soon. It's good to tell your CXOs if you get into the corporate side, or even if you work with law firms, or however you freelance, whatever you do as a lawyer, please know that IPR is the gold. And with AI coming up, there is a war of IPR. Everybody wants to learn IPR. And of course, India government is now putting its mind into IPR. Do you know, when recently 4 months back, our prime minister went down to America, they signed a bond to get into IP financing. Very few people, we Indians don't even know about IP financing, where it is booming in the West. IP financing is where you, on the basis of your IPR, can get loans. Could you even think about this? Yeah, and now India is focusing on it. With the time COVID happened, the number of patents have increased in India. We do not have a very great rank in terms of IPR, and more so not in trademarks, but India government is focusing. And how do I say it? A lot of programs and policies in terms of trademark and IPR has come out in the recent years. Actually, in this year only, NIPAM was launched, and there are many other such policies. So please again go and check the website and refer and increase your knowledge out there. But IPR is not going anywhere. It is only increasing its boundaries. And with digitalization, it's a boom. It's the next biggest boom. After tech, it is IP that is going to boom. It's actually happening all the time. All right. Now, since I've spoken about, that you should register, there is a particular way of registering. That is a very big procedure, which you need to learn by, getting onto something, some courses or whatever, or you learn in your school if they teach you. Will not be able to speak about it here. Apart from that, it is very important that you know about infringement. How does it happens in trademarks? When I started dealing with trademarks for my company, I didn't have to know what is trademark. I didn't have to know, that this is the section under which trademark is allowed, or how should I register. What I had to know was, what is the exceptions to trademark? How can I protect the trademark, which other people might say that, hey, you have infringed? Or what do I do if somebody infringes my trademark? Because when I was dealing with this 35 crores issue right before me, around which some 15-20 cases were lying ahead of me, the only fight was because somebody took over somebody's domain, and that was the fight. That was the trademark war. Yeah, and I only had to understand where are the exceptions, what will be the reasons of infringement, how can I get an injunction order. So in the practical world, when you will come down to the business side, when you will come down to the courts, you've got to understand that you need to understand business, you need to understand the practical. The theory will come into use, but only to give you an idea of what it is. But if you don't understand the practicality, then it takes a little more time to grow. Yeah, so I have been saying this also through my post, that if you guys are looking on the corporate side, understand the business, guide the business, and protect their asset. IPR is their biggest asset, and every company is open to protecting their asset. Why? Because IPR and copyrights are such thing which increases the valuations of company. For my company, I did that, and when we went out to raise funds or get into mergers and acquisitions also, it just almost 75% increase the valuation. You as lawyers will have to recommend all this to the businesses. They will not be coming and telling you that, hey, can you do this for me? You should be knowing it. And how would you know it? When you get hands-on application, or you meet with industry people. Okay, so why I'm sharing so much? Because I want to tell you, get the practical side. All right. So the exception one is to infringement, which is called something as fair use. Everybody first claims fair use. They say, hey, we are doing it under. If you say, you have, used my logo in the wrong place, how could you use it? I will come and say, hey, I was just using it for education purposes. I was using it for just a parody or a satire, or I just used it for, doing my research. So all these categories that I spoke of, they all fall under this fair use. But again, fair use have to be nominative, where you're not crushing the original trademark one person has built, his brand, reputation, goodwill, everything around it. It has to be only as much as necessary. And how do you understand that what you're doing is as much as necessary? Simply, when you're not hitting the brand, if the brand is coming and telling you infringing, it means you're damaging somewhere. That is why the person has come up to you. Do you know there are law firms which just have one particular set of people who are just looking into this, that one brand might not be getting infringed by somebody. So all these big brands, Gucci, Louis, and all of them that you can think of, they pay law firms. They have their in-house teams, where the teams have 5-6 members who are just keeping on checking that their brand has not been infringed. How do you think Barbie and that Red Soul shoe thing, how do you think all of these cases come up? Only when they receive notices? No. That teams, they're paying heavily, these teams, to keep a check that their brand is not being, taken over or infringed. That is also something very interesting when I came to know. So that was nominative fair use. Then there is descriptive fair use. Descriptive fair use, Coca-Cola brings an ad to put down Pepsi. This is descriptive fair use. There is competition, fair competition to a limited time, to a limited space, it is allowed. Again, they are very interesting judgments. You can read it out and understand it. But this is bigger fair use, but still allowed. Then there is parody and satire. So I have used a lot of this explanation that I'm under parody and satire. So when we put out videos for gaming to, showcase our tournaments and to do all the marketing promotions, and my marketing team uses a particular song, like, well, Bella Ciao came in, they used that song and they were like, hey, Rachna, can you just see, are we not infringing? Are we good to go with this? Can we go with this song? We would really want it in a video. It's a they said, it is just only for 7 minutes. It's a parody. Can we? That's all there in the law. We think we are fine. And then we said, okay, we understand, but let us do the checks. And we did all the checks, and we allowed them. Sometimes for the business, you have to take the risk as the legal department, but you have to make sure that the company is in compliance. Just for one promotion, you can't let the company go down, right? Or otherwise there will be too many notices, or YouTube will send you a strike down notice and pull your entire content that you might have built. So that all these social media platforms have very strong copyright policies, very strong trademark policies. So you should make sure that you're falling in the exception category. If you are not even or the owner and you have no licenses around it, you have no agreements around it. So that's it. And the last one is where it's not coded, but it has come by way of a lot of precedents and judgments, is personality rights. Personality rights means today you've become very famous. Amitabh Bachchan, Rajnikant, Shah Rukh Khan, everybody, they have personality rights. Recently, Anil Kapoor got his personality rights. He filed an injunction over somebody, very vicarious kind of websites use his pictures all over. He went down to the Delhi High Court and he sued them and immediately got an interim injunction, whereas many websites were banned for using his pictures, his voice, his image, his way of speaking, his particular dialogue delivery, like jackass and all of that. So another thing which you have to keep in mind is that you are not infringing anybody's personality rights. All of these are exceptions to infringement under trademark. So if you ever think you might fall under that category where you're using somebody's trademark and you're not sure that, hey, will I be stepping over? It's time to check the grounds. What are there under exceptions to infringement and build your defense? Of course, as a lawyer, you will have to build a defense. You cannot always come and tell the business that, hey, you can't do this. You have to check how much of pros and cons are there and let them know that this is a red flag, this is a green flag, 50, 60%, 40% we are good to go. We are going ahead. Let them all know, and then you go ahead. And if then something happens, you be ready with your defenses. That is how the practical worlds operate. It's never 100% green or never 100% red. If it is 100% red, of course, you need to put your foot down as the legal, because you will have to think in the larger interest to save the organizations, to save the client, whoever is on your side, whom you are dealing as a lawyer. But you have to wreck your brains, know it too well to, give it out to businesses. Why I'm saying this after 14 years of working, if you don't add value to the people whom you're working with, then it becomes very difficult for them to add you to the team. That's a reality. If you are only bringing problems, they already have tons of problems. They're looking for solutions here. Yeah. So you have to come from the mind where you show them what's red, what's black, what's blue, and then also offer the solution. That is where lawyers are stepping in now. That is where it's said that you need to know businesses. You just can't sit in today's technology world. I have been telling all my students that if you want to progress in the coming times, and there's so many who are looking to technology law, please understand that you need to be conversant with the businesses and the law. You can't just say that, hey, I'm a lawyer, I'm just supposed to know the law. No, it's not going to work. The better you understand any business, the better value you have in that industry as a lawyer. Yeah, I have had the chances to work with the topmost councils of India, means whose name everybody would know. But one thing that I've noticed, they understand the business for which they stand and talk about. Or if they don't, they will understand before going in the courts or before creating a legal opinion or before even advising you. I've seen that with naked eyes day and night. So I advise that you guys get deep into it. It is not a subject of books. It's a subject about practicality. Yeah. Law is a lot of practicality, understanding the loopholes, getting your experiences, and enriching the others with that. All right. Yeah. And if I can say, what is the career with IPR? Everywhere there is a demand of people who know IPR contracts and something in privacy and technology side. Today, that is the world. If you go and look at jobs, everybody's looking for somebody who knows contracts, IPR, technology. So if you are somebody who's enthusiastic about IPR, I will say, please study IPR. Please increase your knowledge. It's a very good domain. It's growing. And the next 5 years is certainly a boom, boom, boom. Yeah. So you can work in law firms. You can just be an IPR person freelancing. You can be a counsel who would be, of course, looking into the entire IPR portfolio for any organization that you work for. Even a startup has to have some IPR to its credit. Yeah, because the MCA otherwise do not take a particular filing. Do you guys know this? I'm sure many of us don't. So know this. IPR has become that important. Yeah. So study IPR and increase your knowledge, and you can do it in trademark, copyright, patents. It's not going anywhere. It's here to stay. So in very short, that is the basic concepts of trademark, if I could capture it for you. I've given you a lot of things while I was speaking to suggest that what you can research more about. Yeah, from IP financing to looking into the IPR website to understanding what causes infringement, to understanding exceptions. I spoke about all the social media. How do they have their policies? All of this is a lot of things which you can learn from. I've given it out to all of you, yeah, which I usually do otherwise in my courses. Yeah, so that's from my side, and I'm open to all the questions. Yeah. Yeah, Mika, go ahead.
Ma'am, I wanted to understand the role of market research in this field. Like, how do I find out that a particular symbol has not been taken by any other company in order to avoid trademark infringement?
That's a very good question. It's a part of the trademark filing application where you get into public research, search. You do a research by a lot of ways. First is Google, then there is a knockout search, then there is the website search, then there is the USPTO search, then there is a nice search. There are many searches through which you do for all these searches. Of course, again, let me tell you, in US, law firms have big set of people who just doing searches to see if this is available and can be applied for. So sometimes it can also be that, say, let me give you an example. Being human is under category 25, which is for clothes and merchandise. But you want to use being human for something which is absolutely different. Nowhere matches clothing and merchandise. You can use it, but there will be an examination report. You will be objected, but how strong is your defense to get through it will take you through it. That kind of thing can also exist. Or you do all these kind of searches and then you understand that, okay, there is a blanket approval and you can use that particular word, logo, device, whatever it is, to book your trademark.
Got it, ma'am. Thank you. And ma'am, does personality rights also come under trademarks?
It's a combination of trademarks and copyrights. So when they have their images or they have a logo or they have a slogan, they have a particular kind of title, all of these goes under trademark. Yeah, when it is particular things where it is anything which is related to literary, artistic, where something like Jackass, which Anil Kapoor says, it goes under copyright side. But something which represents maybe Anil Kapoor's particular signature, it goes under trademark. Yes, it's a combination of personality rights. Vanshita, can you come up and speak? Is that possible? Or can you somebody from the team? Yeah, please tell me.
Ma'am, maybe I just missed that part. You already mentioned that. Is there any specific list or categories mentioned for that part? Like we can clarify that which is an infringement or not for that particular task we have to do. Like
Sorry, you got to repeat yourself. I did not get you.
hello.
Yeah.
Am I audible, ma'am?
Yes,
मैम
yes,
इट्स
yes.
जस्ट कि कोई लिस्ट या कोई कैटेगरी प्रेजेंट है जिससे हम ये क्लैरिफाई करते हैं कि हाँ इतना एक लिमिटेड एक्सटेंट तक ये इन्फ्रिंचमेंट है हमारे ट्रेडमार्क का या पर्सनालिटी जो हमारे वो थे
See,
marks
there are
थे.
a lot of case laws, but there's no such exact list out there which will tell you, oh, if you use this portion, this is fine, and if you go exaggerate a little more than this, it will. No, law is very dynamic. It
मतलब
really
एक
depends.
extent like some limit of some kind of extent. Any
No,
judgment or any case you
lot of
suggest you
judgments.
suggest
If you can look into judgments, there are variations in judgments. There is no one particular judgment that you can harp on, because if the opposite side, he can bring a judgment which will cross over your judgment. Yeah, so you will have to understand what that particular case is and then find judgments accordingly, because there are both the sides. Sometimes the same thing is a no and the same thing is a yes the later.
Okay, thank you, ma'am. So, is there any case particularly suggest you
No,
like?
I would not suggest anything as such. I would suggest you study for that particular case that is on your mind and search for cases. There are many, because trademark is flooded at the moment.
Okay, thank you, ma'am.
Yeah. Any further questions?
Ma'am, there is a question by Sahil. Ma'am, he asked that deepfakes also part of personality infringement.
Should be. That's a good question. I believe it should be, definitely. But the only question rises here, whom are you going to give this notice upon, the cease desist, where it begins from? Or even if you want to file on an unknown, how will it be taken ahead? Because we do not have a particular way right now or a particular law. The government is thinking about it very seriously. but we have to see. Maybe something comes up in the IT roles in future, and then deepfakes can be taken care of. But it's a good way to think of it. Should come under copyrights and trademark as well. Mohi, this is like I've spoken about the entire Ramayana, and then you're speaking who is Ram. Yeah, what did you hear me for the last 30 minutes? What is the difference between trademark and I said trademark is logo, symbol, what defines your trade. Copyright is anything literature, articles, any further questions, guys? I know
Ma'am,
this was Hmm.
hello, ma'am.
Go ahead.
Good evening,
Right.
ma'am. Actually, I want to ask that in our law school we have only read about a certain part of the IPR, and we do not actually dive into the whole basic internal concept. And
Right.
I have not also done any LLM regarding in IPR also. So is it too late for me to join the IPR sector, or
Hmm.
did I have to do any IPR legal courses to proceed in this field?
See, there are many ways. Prakash, first of all, know that it's never too late, okay? And today the world is proving it every day. You see engineers becoming chefs, chefs becoming, computer software engineers. So there is nothing that you can't follow your passion or learn about something new. So never ever tag that, is it too late? No, it's never too late. If you're passionate about it, upskill yourself and become a pro. When technology was not there, was everybody a technology lawyer? What would happen to all these law firms that have been existing for time immemorial, right? Everybody is upgrading, upskilling in dealing with that particular law, be it AI, be it technology, or be it IPR. So you upskill yourself in whatever best you think will help you in upskilling. Do that. It's of course, I would say articles, I would say courses. I up for reading and writing articles. It really wrecks your brain up. It makes you do a lot of research. I have been on the legal content side, been a content creator, becoming a top mentoring voice. All of this has happened just because I've been writing so much. And by writing, I have so much of clarity. I could speak to you for another last 30 minutes without any slide or PPT, right? How did I do it? Because I'm reading, I'm taking interest, and I'm passionate about it. And of course, I teach it, so I learn more. It's a fact of life that what you teach, you learn more about it. I am a good case of it. Learn, upskill, write, talk about it, read, get into current affairs. I tell you, then you are there. But don't stay back from upskilling. Certifications do make a difference at some point. Yeah, whoever you like, go out and take it up, but train yourself. Don't sit behind. Be like, if you like a good movie, how do you jump to it and go for it the next day? Why is not the same priority given to the career? Yeah, that's it. Thanks. So who's asking has to come up on the mic, guys. I cannot read the uh, chat.
The question by Mohi Gautam is that if two people are using the same mark and the neither is registered, who has more right?
The one who registered it earlier, you got to prove it by evidence. Not even registered, the one who gets into registration and proves it that they had been using it prior wins it, hands down.
If anyone have a question, kindly write in the chat box or you can speak.
Hi, ma'am. Sorry for interrupting. And ma'am, since you were talking a lot of startups and we are relatively new here, so are there